Hi, it's Mike DelSignore. I'm outside Peabody District Court, and this was a court you would appear in if you were arrested for OUI. But in this video, I want to talk about what happens if it's not your first offense, it's your second, your third offense. I've handled these routinely throughout Massachusetts, and in this video, I'm going to tell you if it's your second offense, you'll probably still be released on your promise to appear. You may have conditions such as alcohol-free, depending on the case, the length of time between your two offenses. Now, if your two offenses are separated by 10 years, you could get consideration for a special resolution where you can get your license back as long as you get the interlock device. If your two offenses are within 10 years, you're looking at a pure second offense, so to speak, and a 2-year license loss. Now, keep in mind, when you refuse a breathalyzer and it's your second offense, it's not a 6-month suspension. They probably told you 6 months. The police station, it's actually 3 years based on your prior conviction. If you want to challenge that, you go to the Registry of Motor Vehicles in Boston within 15 days. I usually recommend people challenge those, even though they are difficult to win. The case, in terms of strategy, will proceed the same way. We'll look for video evidence. We'll go to the scene. We'll talk about you testifying. I'll review the report with you to see what the strengths, the weaknesses of the case are, and the best way to fight the case. I've won a lot of these cases, and the field sobriety tests, they're often inaccurate, unreliable. There's a lot of reasons why someone might not be able to walk 9 steps out on the side of the highway. That's not an easy test to do. The conditions, it's difficult, you're nervous. Field sobriety tests, when you read the report, if they say you failed, don't get alarmed by that. Let me go through that with you. I'll show you what you did right. And in a lot of cases, I'll say, well, these are actually helpful to you. They're not harmful. You passed. The officer just didn't acknowledge that in the report, but I'll get him to acknowledge that on the witness stand. If it's your third offense, now you're looking at probably some bail, maybe a $500 bail, likely the sobriety. I would say certainly the sobriety, meaning you have to take a breath test throughout the day to ensure that you're not drinking. Now, when it's your third offense, though, the jury doesn't know it's your third offense. It's probably going to be a jury trial, because many judges are going to shy away from a bench trial on a third offense. But still, the jury doesn't know. So still, our defenses are the same. It's just the stakes are greater. You should get alcohol treatment. Some people ask me, if I get alcohol treatment, are they going to think that I have a problem? Well, you should get the treatment. If you have a third offense, the DAs, the judge, the court, they all think that. You need to be proactive and show that you're taking it seriously. Whether you're guilty or not guilty, that alcohol treatment is going to help you. Your family's going to be thankful you did it, and it might help us get a reduction in the charge to potentially avoid jail time. So third offense, you're looking at mandatory jail time. But I can seek a reduction from the DA. If they agree to a reduction, then I can ask them to reduce the charge. But they're going to want me to write a letter. They're going to want me to say why they should give a reduction. And number one on that list is that you took care of this. You addressed the problems on your own. So third offense, it's a 5-year license loss if you refuse. So definitely challenge the refusal. It's another 8 years if you're convicted of OUI. So there's a lot at stake at these cases. Hire someone that's done these for years, who's always in court on these cases. And that's what I've been doing for the last 18 years, handling OUI cases throughout Massachusetts. And I'd be happy to help you. Call, text anytime, 781-686-5924.